Thank you. Yes, so I will not go through the entire presentation. Obviously, it's too long to fit into this slot. So I would just like to focus on certain contractual and maybe, if we have time, non-contractual relationships. But let me first make clear why we use the term multi-level governance. So maritime sector is characterized by, well, many distinctive issues, but the ones we would like to emphasize are first the fact that there is usually an international element present. So that makes them cross-border. And the second distinctive feature is the fact that there are a lot of conventions which are in force, and many of these conventions contain rules which directly solve the cross-border case. So provisions of these conventions will be directly applicable. And now some of these conventions also contain rules on jurisdiction. On the other hand, EU has unified rules on international jurisdiction with the Brussels 1 bis regulation, which I have been mentioning in the previous lecture, and rules on applicable law for contracts and non-contractual relationships with the Rome 1 regulation and Rome 2 regulation. So Professor Kunda and I have tried to set a sort of hierarchy between these competing sources. So let me start with the carriage of goods. This is the picture of the vessel I'm sure you are all familiar with. This is MSC Napoli, which was carrying, I think, more than 2,000 containers. And what happened is that it was caught in a very serious storm, and there was damage to the hull, and it had to be beached in the UK. And a lot of containers ended up at the shore, and well, there was a delay in production of certain goods. So I would like to use this example and try to establish international jurisdiction. For instance, if the cargo owner instituted the proceedings against the carrier. So rules on international jurisdiction are present in Hamburg rules in Article 21. And Article 21 of the Hamburg rules affords jurisdiction to the court, to several courts, the courts of the habitual residence of the defendant, place where the contract was made, and so on. So there are several fora under Article 21. Rotterdam rules, which are not in force, also contain rule on jurisdiction. And Hague-Visby rules do not contain any provisions on international jurisdiction. As I have mentioned, Brussels 1 bis regulation from 2012 contains both rules on international jurisdiction and recognition and enforcement of judgments. And there is a provision in Brussels 1 bis which explains what is the relationship between Brussels 1 and other conventions. This is Article 71, which basically gives precedence to conventions which were already in force at the time when not Brussels 1 bis regulation was enacted, but its predecessors. And the first instrument at the EU level, which unified rules on international jurisdiction, was Brussels Convention from '68. And however, there is one condition, just to complicate it a bit, which was developed in the case law of the Court of Justice in the judgment TNT Express. So Article 71 is pretty straightforward. In the literature, you can find a list of conventions which take precedence over Brussels 1 bis due to this rule. But the Court of Justice of the European Union played a little bit in this judgment and said, okay, conventions will have priority, but only to the effect that legal standards of the Brussels 1 bis system are preserved. And what are these legal standards? These are cornerstones of the Brussels 1 bis, like legal certainty, mutual trust, and so on. And now, what does this mean? Does that mean that the court, when establishing jurisdiction, should investigate whether a convention contributes to legal certainty? How is it supposed to operate? And now there are, let's say, arguments for interpreting this decision as an obligation to the court to actually go into this analysis. But the predominant view is it's a good idea, but it should not operate in practice. And the argument for this is, first of all, if the Court of Justice wanted to contribute to the legal certainty, it definitely didn't do so with this judgment. The other argument is, if it were the case, why wasn't it codified in Article 71 when the Brussels 1 regulation was being amended and Brussels 1 bis was introduced? So a conclusion would be that this is a programmatic idea, but not an operational device. So maritime conventions, which were already in force and which contain jurisdictional rules, should have priority. If the convention is not does not apply before a court of a member state, then the court will have several options under Brussels 1 bis regulation. First of all, there is the possibility of course, choosing a competent court under Article 25. Is it 25? Yes. Submitting to jurisdiction, so agreeing. This happens when the defendant tacitly agrees to the jurisdiction of a competent court, does not object to the jurisdiction of that court, and just enters into discussions about the subject matter. And there is a provision on special jurisdiction for matters relating to a contract, which represents a special jurisdiction rule, as well as general jurisdiction rule. In contracts for the carriage of goods by sea, Article 25 is obviously often used to establish jurisdiction. So parties decide to choose the competent court. And Article 25, one of its most important parts, is the part which says under which conditions the clause, the jurisdiction clause, or the agreement will be valid. And there are points A, B, and C, which are naturally in, one of them has to be fulfilled in order for the jurisdiction agreement to be valid. C refers to the form which is usual or regularly observed in international trade or commerce. And Court of Justice had several opportunities to interpret what this means in the context of the maritime sector. And these two cases, MSG and Trasporti Castelletti, they actually concern the interpretation of the point C. So facts of the case were that in MSG, MSG was an inland waterway transport cooperative based in Germany who chartered a vessel to another company, Gravier. And they have concluded the prorogation agreement orally. And there was no evidence in writing. So the question was, obviously A is not fulfilled. They didn't have a long-established practice under B, but can we consider that this is the usual way in maritime sector to agree on a competent court? And a general conclusion by the Court of Justice is yes. So this is the usual way. Parties who operate in maritime sector should have a higher standard of care in checking what they are agreeing to and what they are negotiating about. So basically, there is a presumption that the contracting parties are aware and that they have consented to an agreement on jurisdiction. The remaining two cases, Tilly Russ and Korek Maritime, they dealt with something that is connected with the discussion we had yesterday, I think, whether the bill of lading, which contains an agreement on jurisdiction, can be binding upon the third party. In Tilly Russ case, I think the intervener was an English government, or they were, in any case, advocating for the position that it should bind the third party. But the Court of Justice came to a different conclusion. It said that if the prorogation agreement is included into the bill of lading, it will only be binding upon the parties which signed the bill of lading. If the third party gets the bill of lading, then it will be bound by the jurisdiction agreement, but only under the assumption that this third party acceded to the rights and obligations of the original party. And this is to be decided in accordance with the applicable national law. So even though there is an understanding that provisions of the bill of lading may be binding upon the third party, prorogation clause will not necessarily follow other provisions, so to say. And this was confirmed later on in Korek Maritime as well. The case Maersk dealt with the provision of part of the provision of Article 25, which says that the prorogation agreement will be valid unless the agreement is null and void as to its substantive validity under the law of that member state, meaning the law of the member state of the chosen court. And in this case, the enforceability of an English court choice of court agreement was argued between the Spanish insurance company and maritime transport company. And the Spanish company tried to argue that the question whether the third party should be bound actually falls into this part of the provision. But the Court of Justice said, no, this is merely a question of the operation of the jurisdiction agreement, it does not fall into the ambit of the part of provision of Article 25, which deals with its substantive validity. And what happens when there is no agreement on jurisdiction, or agreement on jurisdiction is not valid for some reason? Article 7.1 of the Brussels 1 bis regulation contains a rule for matters relating to contract. And as I have already explained on Tuesday, the provision has 3 levels, let's say. The first level is point A, which says that jurisdiction in matters relating to a contract is afforded to the place of performance of the obligation in question. And then what happened is that the European legislator, when Brussels 1 was being introduced, added point B in order to simplify the operation of this rule for 2 most common types of contract, and this is sale of goods and provision of services. So in Brussels Convention, only A was present. After Brussels 1 in 2001, when it was enacted, point B was added. And their relationship is that the B has priority over A. And the issue here is if A is applicable, so for all contracts which are not sale of goods and provision of services, the court should determine in accordance with the applicable law what is the place of performance of the obligation in question. And that's why B was included, because of it's not reasonable for the court of having to determine the applicable law before even deciding whether it has competence or not. And what happens with the contracts for carriage under Article 7, paragraph 1? The Court of Justice did not explain how this rule should operate, how it should be applied for contracts for the carriage of goods by sea. What is clear, definitely clear, is that these contracts should be characterized as provision of services for the purpose of Article 7, point B, because of the autonomous understanding of provision of services. And according to the Court of Justice of the European Union, this is every contract in which one party performs a certain activity and then gets remuneration. So it's pretty wide. And that means that contracts for the carriage of goods would fall into B, which says that the courts which are competent are the courts where the service is to be provided. So now the question is, how do we determine the place of provision of services? As I said, the Court of Justice didn't have a chance to interpret this, but we can perhaps borrow the court's interpretation in case Reder. And in case Reder, it is a case which concerned the transport of passengers by air. So Mr. Reder was supposed to fly from Vilnius to Munich, and the flight was in delay, and he wanted to sue. And then the question was where he can sue. And the court said that services in the contracts for the transport of passengers by air are performed both at the place of departure and the place of arrival. So all the necessary elements of that contract are performed in these 2 places, which means that the passenger can choose whether to sue before the place of departure or the place of arrival. And the doctrine suggests the rule should operate in the same way for contracts of carriage of goods by sea. So both places should be relevant. Both the place of departure, actually, and the place of receipt and the place of delivery of goods are relevant. And the argument to support this understanding is that the carriage of goods is only finalized when the consignee gets the goods. And we can also draw a parallel with the sale of goods contract, which also specified that the relevant court is the court where the goods were supposed to be delivered. But apart from the place of delivery, also the place of receipt where the packaging is being done, which is quite important, as we have seen from the previous presentation, is, for example, being done. Apart from the special jurisdiction rule, there is a general jurisdiction rule in Article 4 and multiple defendants rule. General jurisdiction says that the competent court is the court of the defendant's domicile. And for companies, the defendant's domicile is autonomously determined by the regulation as a statutory seat, central administration, and principal place of business. And if a company, for instance, has a statutory seat in one member state and the, let's say, principal place of business in another one, then there will be two competent courts under Article 4. For contracts for the carriage of goods, also multiple defendants provision will be relevant. It is Article 8, which says that two defendants can be sued before the court where one of them has his or her or its domicile, as long as there is a close connection between two actions. And the Court of Justice interpreted this provision in a Freeport case, in which it said that the fact that one action might be contractual and the other might be non-contractual does not impede the application of this provision. And this can be relevant for instances in which proceedings are instituted before against the carrier and the actual carrier with whom there is a contractual as well as non-contractual liability relationship. Brussels 1 bis regulation has a limited scope in terms of persons. And this means that it only applies if the defendant has domicile in the EU. There are some exceptions from this rule, but for the provisions of special jurisdiction, the defendant will have to be domiciled in the EU for the Brussels 1 bis to be applicable. So if this is not the case, then national rules of member states come into play. Croatia, for instance, in 2019, introduced a new private international law code, and it did something that some other member states also did, and this is that it extended the application of the Brussels 1 bis provision even to defendants which are domiciled outside of the EU. So we don't have a parallel set of rules for defendants domiciled outside of the EU, but this is not the case with all member states. We still have some time? Yeah, a bit. The next contract that we have analyzed is carriage of passengers. So we all know the vessel in this picture, the Costa Concordia. And there was an article saying that Italian court had a chance of awarding damages to one of the passengers. And the question is how to determine jurisdiction for carriage of passengers contract. So again, we have to check whether there is a jurisdiction rule in the conventions which regulate this area. And the Athens Convention from 2002 contains rule on jurisdiction. However, since Athens Convention was amended in 2002 with a protocol, and it is considered, as I understand, a new instrument, then Brussels 1 bis takes actually precedence over the Athens Convention. European Union has also adopted a regulation on passengers. What is I forgot the entire name, but in any case, this regulation does not, well, it included a lot of the provisions of the Athens Convention, except the ones which deal with international jurisdiction and recognition and enforcement. And this is still governed by the Brussels 1 bis regulation. So which provisions of the Brussels 1 bis apply? I know you cannot see the picture, but this is actually a flow chart on package travel. So the answer as to jurisdiction of a court would depend whether we are talking about the package travel or a carriage of passengers by sea. And there is a flow chart developed by, you can check it on the EU Commission's website. And to put it simply, if there is another service except for carriage, this will be a package travel. So for instance, if there is overnight accommodation, which is agreed in the same contract, so to say. And if it is a package travel, then this will be governed by the protective jurisdiction for consumer contracts in the Brussels 1 bis regulation. So Brussels 1 bis regulation contains sections which protect weaker parties, employees, beneficiaries to the insurance, insured parties, as well as consumers. And these weaker parties are protected in a way that they are afforded a more favorable procedural position, in the sense that they can choose whether to institute the proceedings before the courts of their domicile, consumer's domicile, or they can institute the proceedings before the domicile of the trader. And here in this case, that would be Costa Crociere, who was operating the cruise ship. If it's the other way around, if the trader is the one suing the consumer, then the trader has to do it before the courts of the domicile of the consumer. There is also the possibility, if it's a consumer contract, that the parties agree on a competent court, but there are additional requirements for that kind of agreement to be valid. For instance, it has to be entered after the dispute has already arisen, and this is the way of protecting the consumer, because there is an assumption that he or she will not think about the consequence of agreeing to a jurisdiction clause prior to a dispute. If it is not a package travel, so if we are talking only about a contract for the carriage of passengers by sea, then the same provision would apply as in the instance of the carriage of goods by sea, and this is Article 7, Paragraph 1 of the Brussels 1 bis regulation. So it would be again characterized as a provision of services contract. Apart from that, multiple defendants and general jurisdiction provisions would apply. I think I have ran out of time, so I will leave this for some other time.
Thank you.